Good morning, students. Settle down, please. Welcome to today's Critical Explainer, tailored absolutely exclusively for your upcoming KSLU law examinations. Today, we're going to rigorously dissect the black-letter law of the Sale of Goods Act 1930. Focus your attention completely, because absolute mastery of the exact statutory stipulations governing conditions and warranties is strictly required to succeed in your answer scripts. Let's dive right into it. Here is our exact syllabus for today. 1. Introduction and core meanings. 2. Distinction, condition versus warranty. 3. When condition becomes warranty. 4. Implied conditions in sale contracts. 5. Implied warranties in sale contracts. And finally, 6. Landmark case laws breakdown. Now listen to me. Replicating this exact structural outline on the very first page of your exam booklet will instantly demonstrate your systematic knowledge to the evaluator. So memorize this flow. All right, let's jump straight into Section 1, Introduction and Core Meanings. The definition of a condition under Section 12, subsection 2 is a stipulation essential to the main purpose of the contract. Its breach leads to the right to repudiate the contract, plus claim damages. Now, underline Section 12, subsection 2 in your notes right now. We're beginning with the foundational concepts governing stipulations in a contract of sale, and you must establish this baseline before arguing any complexities. You need to explicitly explain to the examiner that a breach of a condition destroys the very core, the very foundation of the whole contract. Because of this, the law grants the buyer the unquestionable right to just reject the goods entirely, demand their money back, and claim damages. It's the ultimate legal weapon. Now let's look at warranty. Defined in Section 12, subsection 3. It's a stipulation collateral to the main purpose. Breach leads to only damages, not rejection of goods. I want you to emphasize the word collateral in your minds. Highlight it. Instruct yourselves that a breach here is minor compared to a condition. In your KSLU exams, you must explicitly write that. Because it's merely collateral, just a subsidiary promise, the buyer can only claim financial damages. They can never, under any circumstance, reject the actual goods. Do not confuse the two. Moving right along to Section 2, Distinction, Condition versus Warranty. Let's examine this carefully. Basis of importance. Condition is essential. Warranty is collateral. Basis of breach. For a condition, the contract can be repudiated. For a warranty, only damages. Basis of effect. Condition is serious. Warranty is minor. Now pay attention to me. This is exactly what KSLU examiners are actively hunting for in a 10-mark question. You must draw this exact 3-column matrix in your exam paper using a ruler and a pen. Please do not write this out as a rambling paragraph. Structuring these precise differences column by column guarantees maximum marks because it showcases unparalleled clarity of thought. Next is Section 3, When Condition Becomes Warranty. Here are the strict rules. Buyer waives the condition. Buyer accepts goods. Contract is indivisible. The result? Breach of condition is treated as breach of warranty. Listen carefully, students, as this is tricky. We are exploring the rigid legal scenarios where the strictness of a condition is downgraded by law to a mere warranty. First, if the buyer voluntarily waives it. Second, if they actually accept the goods, maybe by keeping them past a reasonable time frame. Third, if the contract is indivisible and they've accepted a portion of the goods. Under these 3 strict circumstances, what happens? The buyer tragically loses the absolute right to reject the goods. You must deliberately explain in your answers that they are legally forced to settle only for damages. Let's move to Section 4, Implied Conditions in Sales Contracts. Look at these statutory conditions. Condition as to title, Section 14. Seller must have the right to sell goods. Condition as to description, Section 15. Goods must correspond with description. Condition as to quality or fitness, Section 16, subsection 1, fit for purpose if buyer relies on seller's skill. Let's dive into this. These conditions are automatically injected by the law into a sale. They are legally presumed to exist unless they are expressly excluded. Memorize Section 14, 15, and 16, subsection 1. Put a massive star next to them in your notebooks right now. These sections form the invincible statutory armor that protects the buyer against fraudulent sellers. Continuing our list, we have condition as to mercantile quality, meaning goods must be saleable and usable, and condition as to sample, Section 17, meaning the bulk must correspond with the sample. You must clearly elaborate in your paper that sample conformity is a completely non-negotiable legal protection. If the huge bulk delivery does not perfectly match that tiny sample you were shown, the buyer absolutely can repudiate the entire contract. Make sure you list these out clearly as distinct, perfectly numbered headings in your final answer booklet. Now, Section 5. Implied warranties in sale contracts. Quiet possession under Section 14. Buyers should enjoy goods without disturbance. Freedom from encumbrances. Goods must be free from charges. Disclosure of dangerous nature. Seller must warn of hidden dangers. Now we're transitioning to the lesser but equally vital implied statutory warranties that hover in the background of all commercial transactions. You need to strictly explain to the examiner that a failure here does not void the sale entirely. That's the key distinction. The buyer keeps the goods, but the seller becomes strictly liable to financially compensate the buyer for any disturbance, any undisclosed charge, or any hidden danger. Understood? Finally, we reach Section 6, Landmark Case Laws Breakdown. We have Baldry v. Marshall here. Attention class, this is the mandatory climax of your answer script. This is exactly where you secure those elusive 16 marks. You must write this precise case name, Baldry v. Marshall, in a separate, boxed format, right in the exact middle of your page using a black pen. I'm telling you, do not bury your critical case laws in long, messy paragraphs. Make them pop for the evaluator. Let's read the breakdown together. Facts: buyer relied on seller for a car fit for touring purposes. Verdict, or ratio decidendi: car was not fit, declared a breach of condition. Relevance: cements the strict application of implied condition for fitness or purpose. Here's exactly how you explain it. The buyer explicitly relied on the seller's expertise to provide a car specifically meant for touring, but the car completely failed its intended purpose. For the verdict, you must use that exact Latin term, ratio decidendi. The court declared this a fundamental breach of condition, not just a warranty. And why does this matter? It perfectly cements the strict application of Section 16, subsection 1. Connecting the ratio decidendi squarely back to the exact statute is exactly how you show true exam mastery. Next case, Grant v. Australian Knitting Mills Ltd. For your second authority, you will likewise draw a neat box around this exact citation. Visually signaling this to the KSLU examiner immediately proves your absolute, unshakable grasp of landmark case law jurisprudence. Let's review the facts. Facts: defective garments caused severe harm to the buyer. Verdict: ratio decidendi. Declared a clear breach of merchantable quality condition. Relevance: proves goods must be fundamentally safe, saleable, and usable. In your paper, you will slowly and deliberately narrate these facts. The buyer purchased woolen undergarments containing hidden, extremely defective chemicals. This caused severe dermatitis and profound physical harm to the buyer. The Privy Council's ratio decidendi? They declared a clear, undeniable breach of the condition of merchantable quality. The goods were completely unfit to be genuinely worn next to the skin. This proves rigorously that goods must be fundamentally safe. It beautifully connects this absolute legal standard to the fundamental fairness owed to all buyers in the marketplace. And finally, our closing thought. Do implied conditions and warranties ensure total fairness, or do modern digital sale contracts require even stricter statutory consumer protections? To cleanly conclude today's lecture, ensure your exam answers summarize how these precise principles from the 1930 Act act as a strict safety net. They ensure fairness even in the total absence of express terms. But I want to leave you with this provocative question to ponder, which you very well might see in your compulsory essay section. Read it again. Do implied conditions and warranties ensure total fairness today? Or do modern digital sale contracts, where you simply click I agree without ever seeing the goods, require even stricter statutory consumer protections? Think critically about that, class. Study hard, ensure your notes are organized perfectly, and I'll see you in the next explainer. Class dismissed.